about that. At the same time, it begs the question of at what point does it become an abstract idea? This takes us back essentially to Parker, Benton, Fluke, and those where we're trying to figure out, okay, if we have a software algorithm, what is it specifically that it's directed to? What is the invention? And is the invention purely algorithm such that it's an abstract idea that can't be really tied down? Is how you're claiming it so abstract that it takes away every other possible implementation alternative? We're going to be going back to those questions, especially for software claims.
Now, do you think that the court or the Federal Circuit or the Board of Appeals at the Patent Office or whomever articulates the test for abstract idea is going to be looking at it through the perspective of a human being? In other words, if what you could do in your own mind, albeit it may take you 6-8 hours, but you can calculate it out, that would be an abstract idea versus a method where it may be so many computations or so many different variables that as a practical reality, no human being, no matter how brilliant they are or how much of a savant they were, they could not possibly get to a meaningful answer within a reasonable amount of time. Is that kind of the test, do you think, that is going to be looked at in terms of it being abstract? Or is it more because you can characterize it in a symbolic way as opposed to an actual implementation?
I think probably both of those are going to be considered. It's going to be a really specific case-by-case almost analysis. The Patent Office, when they are examining claims, I think a lot of times we see the different examiners interpret the instructions differently, and the guidelines that ultimately come down, right now we have a set of interim guidelines, but they're working on a full set of guidelines, and I think when it comes to software claims in particular, whether or not you can perform them in the human mind, if an examiner believes that, yes, technically these could be performed in the human mind or on pen and paper, if you just sit and think about it, I think those will certainly be rejected under 101. The further down that road you move into not, as a practical matter, being able to do it on your own, that moves us towards patent eligibility, but again, it's still in that gray zone.
Well, many business method inventions, if you want to put that label on them, can easily be understood and grasped in the human mind. Mm-hmm. The actual process of whatever is being done mm-hmm. in this business context can easily be understood. Mm-hmm. So, as a practical matter, is the Supreme Court being a little disingenuous with this decision by saying that not all business method inventions are not patent eligible as a practical matter?
I think they are certainly trying to tiptoe softly around the issue. They say that not all business methods are patent eligible. At the same time, it is going to be, they didn't provide any examples of business method claims that they thought would be patent eligible. And without any particular guidance, they may be saying it for the sake of, here's the rule, we're not having a bright line rule, but when it comes to a practical matter, that may be the ultimate effect. I do foresee the go-to rejection for 101 in business method cases to be changed from machine or transformation to, well, now you're claiming an abstract idea, and the burden is going to shift to the applicant to determine and to argue back to the Patent Office whether or not they are not claiming an abstract idea.
So you are being consulted by an inventor. They have a very valuable business method in terms of its bottom line impact on their business. Would you advise this inventor or this entity to file after this decision? And if so, what in particular would you advise them to do that would be reflective of this decision? Anything come out of this decision that you would definitely want to do going forward?
Well, right now, I would advise them to file, certainly if it is key to their business and important to their bottom line. I think it is important to try and protect that as best you can. This decision, as I said, it's unclear. And it's also unclear whether or not the courts and the PTO are going to keep patent eligibility as a gatekeeper, use 101 as the gatekeeper for patentability, or whether they're going to make it less of an issue for these type of claims, as the years go on. I think we're going to need those cases, those close calls, to test the boundaries of where this is. But I think if you are preparing an application now for what is arguably a business method, I think you can write your specification, write your claims in such a way as to really bring in the meat of the invention and write it in such a way that you're not just claiming human activity. Really write it in a concrete, defined manner that you can point to and say, here's what I'm claiming, here are the limits of what I'm claiming. I'm not covering this other area that's not within my claim. I'm really focused on this one particular invention. And I think that would be a huge step in overcoming the 101 hurdle.
Would you put not only describe the invention at a high level, but would you put in more detail on a practical implementation, particularly if it involved either chemical processes or computer measurement, calculation, analysis, implementation? I mean, would you put more of that type of disclosure into your patent application to, in effect, dress it up for being not an abstract idea?
Absolutely. I think the more practical applications that you can assign to your invention are very helpful for the Patent Office to determine whether or not this is an abstract idea that isn't really defined, it's sort of floating out there and could potentially cover a number of things, versus something with a specific implementation that they can then point to and say is patent eligible.
Now, in terms of claiming, would you recommend having different groups of claims? In other words, method claims, system claims, and perhaps so-called Beauregard claims as a way to hedge your bets for getting around this abstract idea problem?
Yes. I think that it's always a good practice to put in different types of claims, certainly with the situation being as it is, where the boundaries are very unclear as to what would be considered patent eligible and what wouldn't be. I think Beauregard claims, for example, really focus computer-related inventions in a manner that has been approved by the courts for many years. And also, system claims in particular, I think, give a good argument of a particular implementation, depending on how they're written and claimed. So I think a variety of claim types and claim styles is really important as we're trying to get through this uncertainty.
Well, perhaps we could go to the next slide, because I'd like to ask you your thoughts relating to the State Street decision and the AT&T decision that was specifically repudiated by the Federal Circuit in their Bilski decision. Do you think that the Supreme Court, in effect, has resuscitated the State Street test as an alternate test?
No, not in any circumstances. And the reason I say that is because they're, in fact, not only in the majority opinion, certainly in the concurring opinions, but also in the majority opinion, there are indications that the court does not take the State Street decision as really solid grounds for patent eligibility.